Hello friends, welcome to my Jits Learn Tech. I'm Prasanth Daimari. Today I'm going to discuss on a very interesting and important topic that is judicial system in India. So before going to the discussion, please like and subscribe my channel and also do not forget to press the bell button. Friends, Indian judiciary is one of the important organs of the government of India. It is an independent body because it has the power of interpreting the laws of the constitution independently and freely without any hesitation. In fact, its main role is to interpret the laws of the Indian constitution whenever any problem persists. Indian judiciary consists of three different level of courts. These are Supreme Court, High Courts, and subordinate court or district courts. Hierarchically, Supreme Court stands at the highest level. It is an apex body which represents the whole country. That means for the whole country in India, we have only one Supreme Court which is located in New Delhi. Next we have is High Court which represents state level. Almost all the states have their own high courts, but there are some other states who have a joint high court. That is, two or more states may have a single high court for them. And in the district level, we have subordinate court or district courts, which operates in the district level. Again, this subordinate court is classified into two different types. These are civil court and criminal court. The judge of the civil court is known as district judge, and that of criminal court is known as session judge. This Supreme Court of India was created as a Federal Court of India under the Government of India in 1935, and finally, after independence, it was founded on 20 June 1950. Now, let us look into the constitutional provisions of the Supreme Court of India. Article number 124(1) states that there shall be a Supreme Court of India constituting of a Chief Justice of India and other seven judges. Articles 124 to 147 also deals with the matters like organization, independence, jurisdiction, powers and procedures of the Supreme Court. So here is a composition of the Supreme Court. Initially, the Constitution of India was provided for a Supreme Court with a Chief Justice and seven other judges. Currently, there are 32 judges, which include Chief Justice of India, and maximum possible strength is 34. As per the Constitution of India, judges of the Supreme Court retires after every 65 years. And right now, currently, we have Sarat Arvind Bhovre, who is the Chief Justice of India. Dear friends, to be a judge of the Supreme Court, one has to fulfill the following criteria. He should be a citizen of India. He should also have an experience working as a judge of High Court for 5 years. He should have been an advocate of a High Court for 10 years. He should also be a distinguished jurist in the opinion of the President. But here it is also to be pointed that the Constitution has not prescribed any minimum age for the appointment of a judge. And these judges of the Supreme Court are appointed by the President of India. The Chief Justice of India is appointed by the President only after consultation with such judges of the Supreme Court and High Courts as he deems necessary. The other judges are also appointed by the President after consultation with the Chief Justice of India and other judges of the Supreme Court and High Courts. The consultation with the Chief Justice is obligatory in this sense. After appointment, the judge of the Supreme Court takes an oath or affirmation before the President of India and swears to work with faithfulness and allegiance to the Constitution of India. Also swears to uphold the sovereignty and integrity of India. He also takes an oath to work to the best of his ability, knowledge, and judgment without any fear or favor or affection. He also promises to uphold the laws and Constitution of India. The judge of the Supreme Court can be removed from his office based on two grounds of removal. These are proved misbehavior and incapacity. If the President of India believes that the judge has misbehaved with the Constitution, or if the President believes that the judge is not capable enough to deliver his duties genuinely, then, then the President can issue the removal order. This is done only after the Parliament addresses him for such removal. And this address has to be passed by the special majority, that is two-thirds of the majority of the members present and voting in the parliament before sending it to the president's office. Next, we have is the jurisdiction and powers of the Supreme Court. So here first comes the original jurisdiction. Original jurisdiction means exclusive jurisdiction, and only Supreme Court has this power of original jurisdiction. This also empowers the Supreme Court to give judgment over all the disputes which occurs between the center and one or more states, or the center and any state or states on one side and one or more states on the other, or between two or more states. Next is writ jurisdiction. Here, writ means an order. So the Supreme Court is empowered to issue an order of writs, including habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the enforcement of the fundamental right of an aggrieved citizen. In this regard, the Supreme Court has original jurisdiction in the sense that an aggrieved citizen can go directly to the Supreme Court. However, the writ jurisdiction of the Supreme Court is not exclusive. The High Courts are also empowered to issue writs for the enforcement of the fundamental rights. Next, appellate jurisdiction. The Supreme Court is primarily a court of appeal and hears appeals against the judgment of the lower courts. It enjoys a wide appellate jurisdiction over constitutional matters, civil matters, criminal matters, and special law. In terms of constitutional and civil, if the High Court is having a question of law, then these cases gets transferred to the Supreme Court. It is done through appeal. In criminal cases also, a convicted person can go and appeal to the Supreme Court against the verdict of the High Court if he is not satisfied. Advisory jurisdiction. Article number 143 of the Indian Constitution authorizes the President to seek the opinion or advices from the Supreme Court of India over the matters such as on any question of law or fact of public importance which has arisen or which is likely to arise. The President can also seek advices on any dispute arising out of any pre-constitutional treaty, agreement or covenant, etc. Court of record. A court of record means all the judgment given by the Supreme Court, High Court, or lower courts are all recorded for the perpetual memory and testimony. Every judgment is recorded. It is recorded so that it can be used as an evidence in further judgment. These evidences are taken as legal precedents and also as legal references for future decision. In the last, we have power of judicial review. A judicial review, it is the power of the Supreme Court to examine the constitutionality of legislative enactments and executive orders of both the central and state governments. On examination, if they are found to be violative of the Constitution, they can be declared as illegal, unconstitutional, and invalid by the Supreme Court. Consequently, they cannot be enforced by the government. In this way, every executive order or bill passed by the center and state can be examined by the Supreme Court through this power of judicial review. So, dear viewers, with this we come to the end of today's discussion on judicial system in India, which focused mainly on the Supreme Court of India. Hope you liked the class. Thank you.